Hello and welcome to the League of Women Voters presentation on the statewide ballot propositions. I'm David Marin, member of the League of Women Voters of Ventura County, and for expert analysis, we're joined by Judge Melinda Johnson. This group of ballot propositions will cover propositions 22, 23, and 25. We'll hear from Judge Johnson as she explains the actual law that's proposed. We'll hear about her thoughts as far as the arguments for and against. The League of Women Voters invites you to make sure you look at your voter information guide pamphlet. This was sent by the Secretary of State to all voters in California. A lot of good information, and it is neutral. It is produced by, the data comes from the Legislative Analyst's Office. They look at each of the propositions and the financial effects. As far as this program, we are neutral. We're not going to tell you how to vote on these issues. We are just showing you the arguments for and against, trying to understand the law a little better, and I think you'll enjoy it. As I mentioned, this is one of 4 programs, so please make sure you look at the other 3 programs. Judge Melinda Johnson, I'd like to go ahead and get started, and we're going to dive in on Proposition 22. This is one where we're seeing a lot of material sent to homes and television advertising. Please explain what this proposition is about.
Every state has a explanation or set of criteria that defines whether a worker is an employee, in which case the employer has certain rights and responsibilities, rights to determine their hours of work and where they work and so forth, and responsibilities, the right to have responsibility to have unemployment insurance, workers' compensation insurance, give them meal and rest breaks, that kind of thing. Or they're an independent contractor. They are someone who is employed only by himself or herself. They come in and do work for the employer who has no rights or responsibilities, as we've just described them. The definitions of those have changed over time, and in a recent case in California, they changed significantly, and a lot of criteria are now examined to decide if someone is an employee or an independent contractor. A lot of that was incorporated into a state law. The Attorney General determined that ride apps and delivery apps like Uber, Lyft, DoorDash, all those kinds of things, were now employers of workers, and this would give them all kinds of responsibilities and obligations. The court, that is still in the court right now, these ride share apps and delivery apps have opposed that, and they're fighting it very hard. So they have put on the ballot a hybrid. They were going to create a hybrid situation where the drivers are not employees, they are not independent contractors, at least not by name. They are something in between. The rideshare app owners will take on some responsibilities for them, but not be fully employers with all the costs that are attendant to that.
So the app-based companies are saying that they're not employers, but anybody that drives for other companies, like say a taxi service, they usually are employees, or at least if they're driving for a delivery company like UPS. Why does Uber or Lyft or DoorDash say that they're not like UPS, for example?
Well, if you actually ask them what their business is, they'll say, we're an app. They don't even mention the driving. We are an app. People use our app, and that's it. They use people, this is the gig economy that you keep hearing about. They use people who want to work part-time, sporadically, as they wish to, and they have made this possible. So they are taking the position that they don't fall under the definition of employers at all.
What are some of the benefits to being an employee versus an independent contractor? Is it significant?
If you are an employee, your employer has to pay part of your Social Security tax, part of your other taxes, not other than income tax. They have to make sure that you're covered by workers' compensation benefits by paying into that system. They have to make sure that you have the unemployment insurance available to you by paying into that system. They have to provide certain daily rest breaks, meal breaks. Rest breaks are paid time off, for example. They just in general participate in a very large system or series of large systems in California, such as disability, workers' compensation. And that's costly. That's costly, but it protects the worker.
And I assume that includes vacation pay and maybe sick pay as well, if the employer wants to offer it. So the people that drive for Uber and Lyft, what I've seen from some of the ads is that they're saying they don't want this. Now, of course, these are ads and they can find people to support anything, but is there a significant view from the drivers that say they don't want to be employees?
It's very difficult to tell if there's a certain percentage who say that because people work for these apps and they may work for multiple apps. So it's a little hard to determine what percentage really don't like it. I honestly don't know when you look at the ads if this is an actor or if this is an actual driver. They're very attractive people, all of them. So I don't know. They could be actors, but I don't know. Flexibility is important. You won't find too many jobs that allow you to check in and check out whenever you feel like it, or agree or disagree to take a job whenever you feel like it, which is the definition that this particular proposition gives to who qualifies to come into this kind of hybrid system. The company can't set specific hours. The company cannot require acceptance of every single ride or delivery request, and it can't restrict you from working for other companies. If the company meets those qualifications, which are very appealing to a lot of people, you know, stay-at-home moms who like a little part-time work, students who have odd hours and need part-time work, then you qualify. So they've created the definition around their own business model.
So the companies that are bringing this and paid for it and wrote the proposition, they make the case that they're actually offering more, as you described it, sort of hybrid, that they're going to guarantee at least $21 per hour for some employees. Employees that work more than a certain number of hours per week will be entitled to certain benefits. They also mention they'll do more background checks, things like that. So are there a significant number of benefits that these companies are offering?
Again, it's a little hard to compare apples and oranges.
Mhm.
The minimum wage in California, except for very small businesses, is $13 an hour. The state analyzes, take a ride app, that these people make between $11 and $16 an hour. So they're right in there where our minimum wage is, but that includes downtime. They're getting paid for waiting time. What this proposition does is guarantee that your minimum earnings will be 120% of the local minimum wage. I don't know how that gets to be $21 an hour. It should be about $15.60 an hour, but you don't get paid for any waiting time. So we're kind of comparing apples and oranges here. At any rate, they are guaranteeing some kind of minimum earnings, and they look at the last couple of weeks to see if you got to that level, and if you didn't, they bring you to that level as their offer of a compromise here.
So the arguments against this, though, is that it's these employers, we'll just call them the app-based employers, or I shouldn't use the word employer.
Hybrid people.
Yeah, the app-based companies have come to the voters of California with a significant bankroll to pass a new law that really only helps them, and that's not really appropriate for big companies to spend that kind of money to keep workers as independent contractors rather than go along with the law that was proposed.
Well, you know, money creates power, and it's not unusual for us to see ballot propositions that are put on solely for the benefit of one employer or one industry. They have the money to promote it. I don't attribute evil intent to them, and I don't know that I would agree with an argument that it only benefits them. It certainly appears to have some benefits created for those people who drive through those apps. I think the objection is largely that they have taken themselves out of the pool that the state of California creates, which needs to have a lot of employers and employees in it to sustain itself, disability payments, unemployment insurance, etc. And they're creating their own kind of similar setups. They're creating an insurance program. They're creating some unemployment kind of money for you, because you're still not in the state programs for that if you're just an independent contractor here. And they're operating these systems. So they create a system, they operate the system. It's not part of the big pool. that causes some problems for the state overall.
Now, the proponents talk about the benefits that they might offer as far as doing this. As far as that effort to give some benefits to these employees, they make an argument that if they had to be listed as employers, they might not even be able to offer services in California. If they also had to be treated as employers, the prices for Uber would go up and Lyft and other services. So consumers might see an increase in costs. Are those valid arguments?
Well, I suspect if they were treated as employers and had all those responsibilities, they would probably have to raise their rates to some degree. Right now, they're in a very anti-competitive mode because, as you said, taxi cab drivers, delivery companies in general who have full-time employees are having to charge more for doing the same service because they have obligations to their employees. So California is a very big state. California is a car-intensive state. We built freeways instead of mass transit starting in the 40s, right? People like to drive in their cars. The notion that you'd raise the rates a little bit and everybody would suddenly stop using it and you'd leave the state altogether feels a little unfounded.
So how does a voter look at this Prop 22? And if that voter doesn't take Uber and Lyft and all that, what are some of the decision-making points that they should consider whether they support Prop 22 or they oppose it? What would drive their values?
Well, part of the value is whether you believe that people should be mostly treated as employees unless they are clearly independent contractors, such as, for example, the cleaning lady who comes to your house once a week but also works for 20 other people. Mm-hmm. She's an independent contractor as compared to a live-in full-time maid who's an employee. So employee benefits have been as much the focus of unionization and labor efforts over time as actually base rate of pay. And the benefits that you have by being an employee are more or less important to you to maintain for all people and to maintain through the common state way of doing it. There's a lot of statements in this law. I always look at the intent of the law. That's the first thing you'll see in legislation. And it says it's to provide the basic legal right to work as an independent contractor. I'm not entirely certain if that is a legal right, but if you see it as a real right of a worker to make that choice, then that might influence you. To protect the legal right of drivers to work flexible hours. Again, I'm not entirely certain that's a legal right, and I'm not entirely certain that you can't be an employee and not work flexible hours. So it depends on how you feel about the employment system overall and whether the state overall has an interest in seeing that employees have the same kind of protection overall. Workers have the same kind of protection overall.
Well, Judge Johnson, next I'd like to move on to Prop 23. This also seems a little bit deja vu, so please explain this one regarding kidney dialysis.
This was on, again, I think it was in 2018, but it could have been 2016. These kind of blend together. This is an initiative to require certain regulations of kidney dialysis clinics. In California, there's approximately 600 of them. They see 80,000 patients a month. They're almost all owned by two particular corporations. And for some reason, some persons feel that they need to be regulated beyond what the federal regulations require. And so this adds the regulations that they must have a physician at all times at each clinic, that they must report all data about infections, would be very common during kidney dialysis, to the state. They already have to report to the Fed and it goes to the CDC. These days, we're not entirely certain what happens to it after it goes to the CDC. They can't close or reduce services without state approval, and they can't refuse to treat any patients based on the source of their payments, be it Medicare, Medicaid on the one hand, or private insurance. So this was on a couple of years ago, as I said, mostly on sanitary condition complaint grounds, and they had to meet certain conditions on that. Did not pass. It's back here with some slightly different focus.
Now, as I recall, when that was on the ballot a couple of years ago, there was a lot of money spent by these two companies. And I guess they're spending a lot now.
Yes, they're not spending as much as they did last time, but they're spending in the millions, and the millions mostly come from the two operators who own most of the clinics.
So you talked about some of the differences. Can you explain what some of the arguments are that are for this ballot proposition and maybe some of the groups that are supporting it?
Most of the employee unions are supporting it. This has been something that stems from labor relations issues with the companies. They say that the need to have these protections in place to assure good, clean, sanitary, safe, and complete care for the patients. They fear that there's overbilling going on for the private insurers to make up for the low payments of the Medicare and Medicaid. They say that there are complaints about discrimination for patients based on the type of insurance they have.
Okay, well, those sort of sound good on face value. What are some of the arguments against this?
Well, the organizations that oppose this, which include not just the owners of the business, but some nursing associations and others, say it will certainly raise costs. It's unnecessary to have a doctor on site all time doing administrative work when that doctor could be doing clinical work, that the patient's own doctors have to see them regularly at the clinic anyway, so it's not necessary, and that it's run under very tight federal regulations, and this is simply unnecessary.
So this seems like a expensive type of way to try and change the dialysis industry. Is this something that the legislature could do?
You know, I suppose they could do, because of the federal regulations. I suspect that the state legislature has not felt this is a top priority for them to step in on. The legislation itself makes initial findings that these dialysis clinics are frequently cited for failure to maintain proper standards of care. I don't know how the state feels about that, but presumably there's federal enforcement available for that, so the state has not involved itself.
Hmm. As far as the dialysis companies, I mean, this is expensive here in California to have to keep fighting ballot propositions. But on the other hand, there must be some reason beyond just labor why people feel that there should be changes. I mean, is it clear what those changes need to be?
This stems from labor disputes, and the dispute is not just unhappiness, but concern by those who work there that sanitary standards, care standards, anti-discrimination standards are not being met. And so I don't treat this as a bad faith proposition by any means. They're not getting any legislation through the state. If they've tried, it hasn't happened, and they're not, in their view, getting real compliance from the owners.
It's a difficult one for voters. If you're not in the dialysis industry, you don't know whether there are a lot of these cases of infections and maltreatment, and whether something like this is needed to improve the industry's health record, or if it's really not necessary because the federal guidelines already take care of some of this. So a little bit confusing, but again, to the voters, read that voter information guide. That's your best source of information to see the pros and cons, and read the actual arguments. But it does seem like this is very narrowly focused, much like the one we just discussed, Prop 22, which was narrowly focused around the mobile app companies. This is narrowly focused around the kidney dialysis industry. Well, Judge Johnson, our next proposition, this is going to be a shock to you. It's narrowly focused around a particular industry here. This is Proposition 25, and this is unique as far as our ballot propositions because it's a referendum. So there is a law that was signed or passed, SB 10, Senate Bill 10, that would replace the money bail system. That was suspended while this referendum is on the ballot because this would remove that law. Can you please explain what Proposition 25 is about?
Universally in the United States, and particularly in California, when someone is arrested for a crime, felony, or misdemeanor, The first hearing for that person is not for at least a few days, and certainly the trial is not for many, many months. So the question becomes, does the person wait in jail until that all happens? Can the person be released by promising to appear again? That's called on your own recognizance, or by posting bail to assure that that person will appear again. Money bail has been studied a great deal by a lot of academic and other organizations, and found to have tremendous amounts of racial and ethnic unfairness in it. Every county has a bail schedule for each offense. There's a presumed amount of bail. Very seldom is it lowered when you're first arrested. It's reviewed initially, but seldom lowered. You're either allowed to get out or you stay in jail unless you post the bail. You can also have it reviewed once you get to court, so forth. This replaces money bail with a fairly complex, hopefully sophisticated, hopefully accurate and unbiased methodology for determining who can in fact be released into the community pending the trial, who is likely to reappear for the trial and who is not likely to reoffend so that they can be released, and who simply has to remain in custody. Money is not involved at all. You can be under this system assessed when you're first arrested. You can be reassessed when you get to your arraignment a few days after you have been there, if you have been in jail, if you haven't been released. You can be reassessed at various points along the way. And all the kinds of considerations that you would expect would go into these decisions. You know, do you have strong community ties? Do you have a history of violent offenses? Do you have a history of failing to appear in court? It's expensive. It requires someone to analyze repeatedly. And the conditions on which you might be released, if it's felt safe to do so, could involve supervision by a probation officer, stay-at-home orders, wearing an ankle bracelet, maintaining employment. So the monitoring of it costs money as well. It's a much more expensive system. It's presumed to be and hoped to be a much more fair system.
So this is Prop 25. A yes vote will approve the 2018 law I mentioned earlier that replaced the money bail with the system you so well described. So initially, if you just think, oh, it gets rid of bail, you may say, well, we need bail. But the way you described it, judges will have discretion and they'll use this type of system to look at the individual and decide whether they should be released or not. They don't have to automatically release everybody who is arrested.
They don't have to automatically release them. They can keep them in custody. And if they release them, they can be on a series of conditions.
Now, this referendum was actually brought, I think, somewhat funded by the money bail industry. And if I'm understanding everything, this is going to do away with bail bonds and that whole bail industry. Is that accurate understanding?
Pretty much. There would be no more bail bonds.
So as far as another reason, though, about bail, I mean, we can talk about the unfairness of it, maybe to different classes of people, but isn't the idea of bail that it guarantees somebody will show up for their hearing or their trial? Because if there was no bail, then they wouldn't have to worry about losing any money.
You forfeit your bail if you don't show up, and so that's an incentive to come back to court. Many people are released on their own recognizance without any kind of bail and show up at court. There's nothing to forfeit. If you fail to appear when you're supposed to in court, it's another whole crime. So that's another incentive to appear.
Well, let's talk about some of the arguments for and against this. Now, you mentioned some of them. Are there other reasons why the people brought this law forward at first?
I suspect they are mostly the social justice reasons that I mentioned. People who it disproportionately keeps in custody low-income people, often people of color, often people who are new to the community, and it has statistically proven to hurt those people. I will tell you personally, as a judge, you see people all the time who are arrested on a Friday night for something, can't make the $500 bail or $1,000 bail. When they come in Monday, they want to plead not guilty and have a trial, but they're still going to be held and they still can't make that bail, and they plead guilty to get out. because the court will sentence them to the 3 days they have already served and they plead guilty. They may be guilty, they may be not guilty, I don't know, but it plays a real role in what people's decisions are about how to handle the criminal trial. This is something that you want to avoid. It's a constitutional problem.
Now, has this been in effect anywhere else, a no bail system?
I'm not aware of any place in terms of a whole state that has no bail systems. I've certainly heard anecdotal reports of individual courts all over the country, or individual district attorney's office and probation offices who have implemented something along this line, but not by virtue of a statewide law.
Now, in California, I believe we have several organizations that are filled with attorney or district attorneys, or they're filled with judges, that type of thing. Is there any sentiment from these judicial bodies, whether they support this or oppose it?
I don't know that any prosecution groups have taken a stand. The governing body for the judges in California is the Judicial Council. I served on that for 4 years. And members of the judiciary and related services are appointed by the Chief Justice to serve on this, which is a policy-making body. And among other things, what they do is create rules. So if under this law, the legislature, as they often do, passes off to the Judicial Council the requirement to write rules that implement this. And these rules would require developing assessment techniques, monitoring it for implicit bias, monitoring it for success and getting people to reappear and not reoffend on an ongoing basis. This is going to cost money. It will certainly require a lot of personnel, but the Judicial Council supports it.
So that's important. So the judicial, which is made up of judges, believes that this is a good ruling or good law, and they support a yes on 25. You mentioned also about trying to remove some of the inequity of our system as far as low-income people being stuck in jail because they can't afford bail. But when I look at the arguments against this, I see that some of those arguments are that this is unfair to minorities, African Americans, Latinos, because they may be singled out and have to stay in jail, not given the opportunity of taking advantage of no money bail.
I understand that they do have some objections to this, and I think it probably stems from the historical fact of their being inherently seen as more risky and being discriminated against in just that fashion. The whole goal of this is to develop assessment techniques that will minimize that kind of bias, and that's part of what the Judicial Council has to do, continually reevaluate this. And there's also the possibility of, as I said, these other conditions that will allow you to be released without any kind of bail, but that will add a little extra assurance of your reappearance.
So as far as those arguments, it seems to me that who makes the actual ruling about the decisions? Is it each local county judge who can decide if people get out for things, or is it statewide?
It will be the assessing person in each county. So the initial assessing person when you come into jail will probably be someone from the probation office or some other entity that examines you and makes a decision. If you don't get out from that assessment, when you come for your arraignment, the court will probably have an aide who will help assist in assessing. You'll have opportunities along the line, but it will be in the individual courts.
Okay, so this then means that a yes vote, we eliminate bail bonds, we eliminate the bail system, and we go to a new system. We're not just eliminating everything. We have a new system where judges at their somewhat discretion based on statewide regulations will be able to decide if people are safe and meet criteria to be released on their own recognizance.
With or without conditions, right?
With or without conditions. So those conditions could include an ankle bracelet, as you mentioned. I see. So for voters, it seems like this comes back a little bit to sort of values. I mean, do you think that the system currently is ineffective and it's necessary to give people more of a chance to be released, even if they don't have the financial wherewithal to pay bail? Okay. Judge Johnson, Thank you again for another ballot proposition. Very explained extremely well so that we can all understand it. And for our viewers, this concludes our this current session, group 3 about ballot propositions. This is one of 4 that the League of Women Voters has recorded. Please look at your or visit the other presentations so you can learn about the other ballot propositions. And also look at the screen as we fade out here with more information and links for you to follow up and get more information. I'm David Marin with the League of Women Voters of Ventura County. Thank you for watching. I want to extend our great appreciation to Judge Melinda Johnson for providing her expert analysis. Thank you for watching, and please, if you vote by mail, remember to sign your ballot and get it in early. But the election is November 3rd. Please make sure you vote. Thank you.